gives me real pleasure to chair this session, and I'm joined by four very experienced, very different individuals who come at pro bono work from a number of different backgrounds. So I think that will lead to a really interesting and hopefully thought-provoking discussion. I'll introduce each of the four to start with, and then we'll ask each of them to give a sort of 5 to 10 minute introduction. The first speaker will be James Sambach from LawWorks. The second will be Victoria Channing, who's the pro bono manager at Simmons & Simmons. The third speaker will be Nathan Fitzpatrick from the Law Centre Network. And then Elaine Hall from Northumbria University will finish off. So that's going to be the order. And I think Stephen has flagged up a number of things for us to look at, and I'm sure that we will be touching on a number of them throughout the discussion. But I think probably most importantly for the purpose of the next 50 to 60 minutes will be the value of the pro bono contribution that is made by members of the profession and those who contribute from outside as well. So we're going to be looking very much at the value of that. So I wonder, James, could I ask you to start off, give an introduction and perhaps speak for up to 10 minutes, and then we'll move on to Victoria from that. Thank you.
Okay, well, morning everybody, and thank you very much for coming to this seminar. In fact, I'm really glad that it's all come together, because when Omar came to us last year with this idea, we thought it was a very interesting one that we wanted to take forward, because we often don't talk about pro bono and pro bono activity and pro bono work within an ethics frame. But ethics is actually very relevant to all pro bono activity. And I think I should say something first about my own background, in that I mean, I'm Director of Policy at LawWorks, but it's probably not even known to my closest colleagues that, in fact, my first degree was actually theology. I wanted to be a priest, so therefore I have a very strong sort of interest going back a long way into ethics, ethical issues, moral issues. But then I sort of diverted into law, and now I studied law, and I was very fortunate to know and be taught by some of the sort of great legal scholars like Ronald Dworkin and William Twining and other sort of big names in jurisprudence who discussed a lot about the relationship between law and ethics and professional practice. But it's because of a long-standing interest in access to justice and working in the access to justice sector that I've sort of ended up in LawWorks. LawWorks, do we see ourselves and define ourselves as being an access to justice charity? And that's very much written into our objectives, that when we see pro bono as facilitating access to justice, but not in any way as an alternative to publicly funded provision. And in fact, really, it's very much part of our mantra that pro bono cannot and should not replace publicly funded legal aid. And that in itself is an important sort of moral and ethical message. John talked about, John has asked about how do the panelists see the value of pro bono? And there've been lots of studies in which have tried to quantify this, but it's actually very difficult to quantify, because there's no sort of common metric that works really across the profession and across the sector. So it's difficult to quantify. There's a lot that can be quantified about the value of people receiving legal advice, and that actually helps people to avoid adverse consequences in their lives that can cost not just them a lot of money, but the public services a lot of money as well, and cause health and mental health problems. So there's clearly the value there. But I think there's a value also to the profession. And that value has always been there. So pro bono has a long history. It goes pre-legal aid. There were back in the early part of the century when lawyers took up what were called doc briefs for free, and this has been going on for a very long time, and it is, written into the messaging of the Law Society and the professional bodies that pro bono is part of being a lawyer. But I think it's also important to emphasize that it's a voluntary activity. And so at LawWorks, we've always been very resistant to ideas of pro bono becoming in any way mandatory or compulsory part of professional legal practice, because by definition, it is pro bono publico and it is voluntary. It's for the public interest, but it is voluntary activity. It is voluntary activity undertaken for the highest of ethical and moral reasons. So that's really important to emphasize. And certainly when LawWorks is a membership organization, so firms join LawWorks and they become part and they work on, deliver pro bono through our programs. But we do not have what is in any way could be called a kind of pay to play model. And we do not require that member firms kind of sign any kind of contract or expectation on delivering a certain number of minimum pro bono hours or anything like that. It is because that in itself would undermine the sort of voluntary ethos of pro bono. And in the US, it is of course different. In some state bars have embraced the idea of mandatory pro bono as part of training and professional development. I think, but we're not there in this jurisdiction at all. And where I think there are opportunities, the new solicitor's qualifying exam does give the opportunity to do some qualifying work experience in clinics. But again, it doesn't have to be done in clinics. And I think that's really important to keep the voluntary elements there at all times. And what does the way that pro bono I think is best captured is if you look at our annual clinics report, and this our clinics reporting from last year showed that over 70,000 people were helped through clinics, and that's a very significant number. And that's a very significant number. Through help by volunteers who may be students, who may be solicitors, who may be and others working in clinics. And that's a strong ethical message about the profession, about its commitment to access to justice, and it's about its commitment to everybody being able to have access to the rights of being treated equally and well under the rule of law. So I think that's an important message that really we need to make in this pro bono week, as we made in other pro bono weeks, that it is part of being a lawyer, it is part of professional values. It doesn't replace publicly funded work and shouldn't replace publicly funded work. And we should do everything we can to encourage it, including arguing for a regulatory regime that facilitates and is supportive of pro bono. Now, that doesn't mean that pro bono should be treated differently. And I think the charters, the principles that are written in the pro bono charter and the protocol, the LawWorks, the protocol that's been produced by the Law Society, the Bar, and Silex, lay down some really quite important principles about what is pro bono work, that it has to be done by lawyers who have an appropriate level of knowledge and skills, that it's work without payment, it's legal work, it's work without payment, and that it needs to be done with the level of care and the level of expertise that you would expect from a profession, from paid work. And that's really important. But I do think in the way that the regulatory regime is constructed, and Stephen Mason picks this up in his report, that you have, in a sense, very high, you have a certain amount of activities i.e. the reserved activities, which are very highly regulated, and then you have other activities which are very lightly regulated, if at all. And in some sense, there's a lot between that, and there's a lot of grey areas. And I think Stephen's overall recommendation that we need to think about regulation more of a risk-based approach is generally the correct one, because it is about risk, the risk to the consumer. So obviously with pro bono work, because there aren't financial transactions involved, pro bono lawyers don't owe client money. There's a different matrix of risk there, and that's important to consider. So I know other panelists have other things to say on this subject, but those are my initial thoughts. And then I'll hand back to you, John.
Okay, thank you very much, James. I mean, that's sort of flagged up a number of questions that I would quite like to put to you, but I think I'll save those for the end once we've heard from each of our 4 speakers. So I wonder if I could ask Victoria from Simmons & Simmons to perhaps take over and talk to us about pro bono from your perspective, Victoria.
Absolutely, thank you so much. Now I'm interested to hear that there's a general consensus that pro bono should form part of a lawyer's work, and that we have an ethical imperative to become involved in that type of work. And I, for one, have certainly, as a lawyer, always been part of the pro bono sector. Initially as a student, I worked with the Citizens Advice Bureau and then started advising at legal advice clinics at law school, and then continued with my pro bono journey once I entered Simmons & Simmons. And now I have recently taken on the role of pro bono manager at Simmons & Simmons, which means that I am responsible for our pro bono practice worldwide. So we operate in the UK and Ireland, Middle East, Asia, and then Europe as well. And our lawyers do pro bono in over 20 offices. So my job is essentially to encourage all of our lawyers to engage in some form of pro bono. And I also work very closely with the newly formed in-house pro bono group, helping our fee-paying clients and their in-house teams build their own pro bono practice. So this is certainly central to my life as a lawyer, and also the values of our firm. More recently, I've also been trying to encourage regional networks outside of the City of London to really focus on local need in terms of pro bono. And as part of that, I've recently taken on the chair of the Bristol Pro Bono Group. So prior to my management role, I used to work full-time as a commercial litigator. And as I said, in that role, from a very junior position, I did a lot of pro bono, specifically on the human rights and business side, and the implementation of the UN Guiding Principles of Business and Human Rights, working for quite a lot of large NGOs who are predominantly based in Latin America. So our work comes from a number of different sources. I know that a lot of people today, my fellow panelists, will be focusing on the provision of legal advice at legal clinics because that's their specialism. But we at Simmons, not only do we advise at legal clinics, but we also take on individual casework for those who do not qualify for legal aid. And we have an award-winning benefits appeal program where we take cases to the tribunal, where we've had a phenomenal success rate. And we also take on clients, not-for-profit clients looking for day-to-day legal advice or strategic advice to work with us on a long-term basis on larger, more impactful projects. More recently, we've been working with Thomson Reuters on educating the judiciary in Africa on the worst forms of child labour. I have spent many hours working on Human Rights Defenders Toolbox, which is the first online resource for human rights defenders working in Latin America. And we have lawyers in Asia, for example, working with domestic workers on their rights. So that's just a little bit of a snapshot as to the sort of work that we as a commercial law firm get involved with. But moving more specifically on to the ethical considerations, as a manager, I come across these issues on a daily basis in my work. And they might involve looking at the different and arguably conflicting rights that we are protecting through our pro bono program. So that might be some quite lively debates on whether assisting trans organizations actually conflicts with work on women's rights organizations, which is very very current at the moment in the news. We also have quite a lot of debate as to whether where we have clients where there's not actually any legal conflict from a pro bono basis, whether we should be doing that work because we have a commercial conflict with some of the fee paying work that we do. And also we are constantly looking to ensure that our junior lawyers, our paralegals and the students from the universities that we work with, specifically on the legal clinic side, are sufficiently trained and supervised for providing advice to individuals within a clinic context. I should also add that some of our more senior lawyers also require quite a lot of training in order to ensure that they are fully equipped to give that advice as well. So in short, we value pro bono at Simmons & Simmons, as do many of the larger firms across the country and indeed the smaller ones. And that's because on a personal level, we believe that we are doing the right thing and we should be contributing to the pro bono sector. But also from a business development perspective, it is very fruitful. And it also leads to increased professional development, specifically for our more junior lawyers. And that poses quite an interesting question. Does it matter from an ethical perspective how you come to do pro bono? Should it be very much a quest for to do the right thing within our own society? Or is it acceptable that actually individual lawyers are using the pro bono sector and the opportunities within that sector to increase or boost their CV or boost their client portfolio? For example, many law firms will encourage their lawyers to do pro bono by saying that a certain amount of hours will count towards their billable targets. So there's certainly a personal financial incentive to pick up a pro bono case. I, for one, as a pro bono manager, don't really mind how people come to pro bono as long as they do the work and they do it well and enthusiastically. But that's certainly an interesting debate that we could have and carry forward today. So in short, I think the way that we view or I view pro bono ethics within my day job is very different to those who are specifically in law centres. I have a slightly larger portfolio of types of cases that I have to work through on a daily basis, along with my partners. And it is something that we do consider on a regular basis and include some quite hefty guidelines within our pro bono policy to help us decide how we move through and resolve some of these issues. So I'm looking forward to discussing all of that a little bit further with my colleagues today.
Okay, thank you very much, Victoria. Just as was the case with James, you flagged up so many issues and questions that I would like to sort of pursue, but I'm sort of really holding myself back at the moment from doing so. Nathan, from the Law Centre Network, I wonder if you would like to sort of take over the next 10 minutes or so.
Certainly, thank you very much, John. And I'm the same as you, I've got all sorts of questions, so I'll try and be quick so we can get to that discussion quickly, because I'm really looking forward to it as well. So I'm, as I've been introduced, I'm Nathan Fitzpatrick from the Law Centres Network. My role with LCN, which is the umbrella organisation that works with law centres all across England and Wales and Northern Ireland, is Learning and Transformation Lead. which I'm still, to be completely honest with all of you, figuring out exactly what that entails. It seems to be quite an awful lot of things. It's a role that I started since lockdown, so that's been a fun challenge to take on. But that includes development, training, and a substantial amount of pro bono work, and looking after law centres that do pro bono and support law clinics and other types of pro bono work. I've had a little bit of an interesting sort of route into this work as well. I used to work at Bristol Law Centre, so another link to Bristol. And one of my main roles, one of the jobs that I did when I was in Bristol Law Centre was working with our legal advocacy support project, which was the student pro bono project supporting students to do appeals work, benefits appeals work as well. So did a substantial amount of that kind of work in Bristol, as well as developing the project to try and make it work differently. And a lot of the things that we've been discussing so far today about the ethics of the approach, about the professionalization, the routes into pro bono and the routes out of pro bono as well, sort of where they lead to, was a lot of the considerations when we were redesigning that project. We also in Bristol and across the law centres in general, all sorts of other sort of types of pro bono. So there's the student projects. We have LawWorks clinics that work with a lot of our law centres across across the network, doing all sorts of different types of work, and I'll come back to that in a little bit. But we also have another type of pro bono that I think we don't always acknowledge that much, which is when we have colleagues who work for free because the type of work that they need to do isn't funded. The most sort of obvious occasion of that is exceptional case funding applications, which by and large you don't get funding to do, even though you do get funding, hopefully once the ECF application has been agreed. But you do have situations in which lawyers who are already working in charities and on what could very much be called, work for the public good, have to work for free in order to get paid later on, or to get their case funded later on, in fact. So there are the sort of pro bono, I think, and the ethics of it can get quite complicated in that direction as well, and it's definitely something worth pulling out. The only other sort of experience of pro bono I can really think of is I'm also a law student, sort of on a part-time basis, and have done a little bit of pro bono work myself in that way as well. So having seen it from sort of multiple different aspects, I think you do get a very, very different idea of what it means and what it feels like to be doing pro bono work, depending on the direction that you enter it from. The thing that I think I really wanted to bring to this discussion is taking on the transformation element of my role and talking about pro bono as a transformative act. I mean that in a couple of different ways. One of them is that by doing work for the public good, you are attempting to have a transformative influence on at least an individual, but potentially much more than that. So you're working within the community to try and transform the community to make it better. And I think that's a very, very laudable approach, and really, a great reason to do this kind of thing. There is either an injustice or justice that isn't being met or defended, and we have lawyers with the skills to do that work, working in their community to uphold rights, to support people, to do work that makes the community better. The thing that I think we all know, but maybe don't always talk about as much, is the way in which doing this work is transformative on the lawyers themselves. And I don't only mean professionally, as we've talked about already, but also personally. And I think that's something that really is actually bound up in the ethics of pro bono and the sort of the moral imperative I think we've talked about already, but it's really bound up in that in a way that I think is worth teasing out a little bit. It's one of the ways that the profession prevents itself from becoming disconnected, and I think disconnected is a theme, during this time of Zoom conferences and COVID and not being able to meet each other, that we really do need to consider. But it's been something that's been a theme and an issue within this sector and within this type of work for longer than the current crisis as well. I think the approach of having a pro bono session where you go in, do some one-off advice, and then go away and never have to think about that case again, it's not true. That's not what happens. And I think we all really know that. You know, generally speaking, of course, there are some situations where one-off advice is all that someone needs, and that's wonderful. But more often, there's more of a connection than that. And I think thinking about pro bono as a way of getting back engaged with our communities, about understanding our communities better, and about knowing what the communities really need from us is something that's really worth thinking about. And so the ethics of beyond the regulation, beyond the sort of professional approach to things, the ethics of actually being open to hearing the story behind the law and hearing what a community is actually crying out for, and not necessarily immediately saying, okay, well, I know which application I need to make, although that's very important as well, but also thinking about what the role is of being a lawyer in a community that's crying out for some kind of help. It's something that I think a lot about. It's not got an easy answer, but I think the approach of transformation, the approach of community connectedness, and the approach of actually bringing yourself to pro bono work and letting yourself be changed by it is really, really worth having as part of this conversation. So I'll pass back to you now, John, and hopefully we can come back to some of those things.
Excellent. Thank you very much, Nathan. Elaine, can I hand over to you for the next 10 minutes or so?
Certainly, I will I'll very much try to keep to that, although I've already changed what I was going to say about 5 times as people were speaking. I'm so sort of buzzed by everything that people are saying. I have the enormous temerity, really, to be here representing clinical legal educators. I'm the managing editor of the International Journal of Clinical Legal Education, and I'm standing here really specifically on behalf of my colleagues at Northumbria, where we run the Student Law Office. The Student Law Office is a compulsory part of our undergraduate programme. So all of our students do clinical work as part of their degree. And this is something that evolved quite naturally in the sense that we used to have a dean of the school who was allowed to do whatever he liked, and this is what he liked. So we are very unusual in terms of a university clinic, because we don't have to worry about clinic being an adjunct. We don't have to worry about it being something that we have to select our students for, and it's at the core of the law school's business model. We get a lot of support. We are incredibly well resourced. It also puts a great deal of pressure on, because we're not just working with those students who want to do clinic, we're working with all of the students, and we have a regulatory duty, just sort of harking back to Stephen, to make sure that all of the students that come on our degree get some kind of comparable experience, which contributes to their professional competence, because in the SLO, we assess their skills. We don't just ask them to do the thing and reflect on it, although there's nothing wrong with that, but we are, I say we, my colleagues who supervise in the SLO are looking at all of the aspects of professional competence and giving our students grades on those various aspects. So when we think about it in that way, we're sitting in an interesting place in the clinical tradition, because as James alluded in what he was saying, there has been a tradition, particularly in the US, of clinic as triage, of clinical programs in universities providing services that the profession are literally unable to do. They are overstretched, or those services do not exist. We're not in competition with those services. We're essentially trying to get people into the system. So we are the kind of slightly more upriver solution to unmet legal need. Now, that's absolutely fine. And there are so many examples across the world of clinics, both generalist and specialist, doing that kind of work. And it's immensely valuable. But when you put that together with an ethical duty to a body of students, you can't just do triage work, because you can't know for sure that you're going to have enough immigration clients next year. You can't know for sure that you're going to have enough family justice clients next year. You have to essentially start to run your clinic like a generalist practice, which is what we do. So we have students operating across the legal spectrum. We do everything from welfare benefits, small claims civil cases. We do criminal appeals and criminal representation with our bar team. We do family. We do research projects. So we do commission policy projects, but we also work with local solicitors on the kind of pump priming work that Nathan was talking about. Most recently in relation to historical sexual and physical abuse at a local detention centre. So we do a lot of that work, but we also do things like business advice and financial advice. When we started doing that, some people in the clinical world suggested that we might be trying to bring down pro bono and clinic by, getting the evil money business side into it. Our view is that many of our students want to work in those areas and have almost no opportunities to get any kind of vacation placement or any kind of work experience in those areas. Although our student profile is changing, we are an ex-polytechnic in the northeast of England. We're a long way from the big dogs, and we don't have, on the whole, students with a lot of family contacts. So we have a duty, we feel, to provide experiences that span the range of the legal profession, and to try and give our students those kinds of experiences that they can then take into interview and say, there's a reason why you might want to hire me. So when we get into areas like small business, then there is an issue, I think, that James has raised it, that we might in some ways be treading on the toes of local small practices. We try to consider the nature of the clients that we're taking in, but we don't triage according to people's potential clients' income or potential clients' standards. We actually make a decision based on the educational value for our students. So there is a murky area there for us that we're very aware of. To sort of move on from that, we also, I think, want to see ourselves in the mode of legal activists by giving our students a taste of how complex and difficult real-world legal problems are. What our colleagues at LSBU call the plastic bag problem, where a client doesn't come in saying, I've got a housing issue. They just come in saying, my life is in chaos. How do I move on from here? What's the first thing I have to do? And once the students have done the analysis, they say, well, you need a house, because until you've got a house, you can't do any of these other things. So this, that sort of thing. And I think that is transformational, to borrow Nathan's phrase. It is transformational for our students because it takes them away from that ghetto silo way that we all teach law subject by subject, as if they weren't interlinked in people's personal lives. So whether or not it makes them better people, it certainly makes them more flexible and complex thinkers. We do think also that the range of things that we do contributes to an idea that doing good doesn't have to be in specific places. Voluntary work that eases civic society most broadly and that connects us up as far as possible is all part of the pro bono. So I think in that point, we're sort of moving towards a more professional ethics space, as Stephen's framed it for us today. I wanted to just also talk about the benefits to our staff and to the university. So we do this obviously because it's a good thing for our students. What that means is that we can employ really quite a large number of people essentially to do pro bono work. So they have academic posts, and of course they read and write and research and teach on other programs as well. But a chunk of about 25 people's contract is to teach in the student law office. So the university is making a significant pro bono move here. And it's important that the university sees the benefits that they're getting back, not just in terms of being more deeply embedded and useful in the community, but in terms of the way in which we take a reflexive turn on the work that we do. So that's where things like the Journal, the International Conference, our partnership with other institutions throughout the world and with LawWorks, that's very important. We need to be seen to not just be doing pro bono work, but really thinking deeply about what we're doing, how we're doing it, how we're measuring impact, whether our measures for impact are in fact measuring what we think they're measuring. All of those sort of really critical academic activities. That's really important for the SLO. We can't risk being an adjunct to the core business of the university, because what we see elsewhere in the world is that where clinic is an add-on, it can be chopped off. And because we believe it's central, we have to make it central. And so then we're into difficult ethical territory about researching into our own practice, into the lives and experience of our students, into the lives and experience of our clients. So there's a whole other ethical can of worms that's going there. And I will pause at that point because I think I've just thrown another 6 hats into the ring. Over to you, John.
Okay, thank you to all 4 of you. As I was saying as we were going along, there were so many points or questions that I had from what you were saying. But I think the overall theme that I'd just like to sort of pick up on and ask your views on comes back to the point that Nathan was making about the transformative nature of pro bono work, because it seems to me that that actually taps into what Victoria was saying in relation to whether or not it matters why somebody does pro bono work. And similarly, in relation to what you were saying, Elaine, about not being oblivious to, if you like, the benefits, not just to the staff, but to the university. And arguably, whether or not the university encouragement of law clinics is actually a quite cynical point on their part, because it seems to me that the majority of law students or aspiring law students now are going to be looking for institutions where they can get more than just a degree. And therefore, if they've got the opportunity to get really good legal experience, then that's something that will be a big plus factor for the individual institution. Just as an aside, I teach clinical legal studies at Bristol University, and I was talking to the students last week, in fact, as to why they were doing clinical legal studies. The majority of students do clinical legal studies because it gives them an entry to the law clinic. And I then said, well, why do you want to work in the law clinic? And it's split fairly evenly, because those who I would say want to do it because they actually want to help people. But there was also a sizable chunk, if not a small majority, who said, I do it for employability reasons because it looks good on my CV. And I don't think we can ignore that. But it brings me back to what Victoria was saying, because my answer to that is, as long as you're going to do the work properly, professionally, and to the best of your ability, then I don't really mind what your motive is, particularly if during the course of your involvement with the law clinic, what might have been a relatively selfish motive at the outset develops into a longer term commitment. So I didn't know whether any of you wanted sort of to pick up on any of those points, but it seems to me that they all tie in together, really.
I can certainly comment on that. I mean, one thing that I've seen shift over the past 6 to 8 months during the pandemic is the change of the provision of legal services. So by that, I mean that a lot of the legal clinics that we used to work at were in-person appointments where our lawyers had to sometimes make quite a substantial journey across, as was then the city of London, to take 1 or 2 appointments and then make their way home again. And sometimes for our lawyers, that included, you know, a journey of 2 hours or so as they were going back to the suburbs. Now we see clinics operating increasingly remotely. So a lot of those appointments are now taken by Teams, for example. Which has increased our numbers of our volunteers exponentially. It's really quite shocking how many people have now signed up to it. Now, that's very much about the convenience of the provision of pro bono for busy commercial lawyers. They can now fit it into their evenings without too much additional stress or time, and they can package it up and then get on with their evening. Now, whilst that's great in terms of volunteer numbers, I raise a question as to whether that's fantastic, so fantastic for the clients which we are servicing, because actually many of those individuals are vulnerable individuals who perhaps do not have English as a first language, or are suffering from wider social or mental health issues. And actually, in order to resolve some of those issues and to understand what the key legal issue is that they are presenting, it's often essential to be present in a room with them and to sift through that bag of that plastic bag of documents, as Elaine was referring to. So although that's been transformative for my pro bono practice at Simmons & Simmons, and we've certainly upped our pro bono hours, which is always a great thing to report to my manager, I am very conscious of the fact that if we continue down this path, we are not actually delivering the service that we should to those individuals, and indeed the service that they deserve. And that for me is a bit of a niggle, and that's something that I'm working with my colleagues across the city in the pro bono world to address. So that's an interesting example of how you balance the transformative nature of pro bono work for a legal professional, or indeed a law firm, with the actual end result with your client and the service that they actually experience and the advice that they actually receive.
You were talking about the reasons that people do pro bono, and I, again, having worked with lots and lots of students doing pro bono, we saw all sorts of reasons that people were joining. And I just to echo what Elaine was saying, we saw Peter, Paul, and John, what you were saying as well. We saw people who were very much just doing it for the employability, and we saw other people for whom it was, I'd go as far as to say it was really a kind of a calling. And we also found that both of those types of people could be brilliant at the work they were doing, or not great, actually, and that it was a real mix. And I think we talked actually in the prep discussion about this, about it can be very, very difficult to figure out who is going to be a great pro bono advisor, in that sometimes the people who are doing it for all the right reasons can't keep up, and sometimes the people who are academically brilliant can't relate, and sometimes the people, and then there's all sorts of different reasons that you sort of get a feeling sometimes, but the proof is always in the work. The other thing really quickly I just wanted to flag up is, I think so that's one of the great things is watching people come into pro bono for one reason, and then that change, and either the people who came into it as a calling find themselves with great employability, and the people who came into it for employability find themselves loving the work, and then they end up being a welfare benefits advisor, and we get one. But the other thing is actually just to kind of throw a challenge out to pro bono, and just to say that we've got to be really careful that it's not just the people who can afford to do pro bono who do it. And what I mentioned earlier about being changed by your community, and about being able to hear the voices of the community and hear what the community is asking for, I'd expand that even further and say that it's really, really important to make sure that the community is represented in the advice that it's able to provide to itself. And I mean that in terms of identity. So I mean that in terms of making sure that people are able to be part of the discussions that that are about themselves, whether that's about, we mentioned women's rights earlier, and we mentioned trans rights, and I want to expand that to talk about queer rights in general, but also about race, and about all of the different parts of identity and discrimination that are going on. And actually, pro bono can be a fantastic opportunity to get more people into the profession, to give more people the experience that they actually need to become a lawyer, or whatever they're going to do, but to be part of the conversations that affect themselves. So I think again, that's a bit of a sort of a messy statement, but just to throw it open a little bit more, I think it's something else we've got to talk about.
If I could jump in after Nathan here, if that's okay, John. I think this is exactly, the mess is really important for us to focus on. I think the point about transformation is that it's not, real life is not the very hungry caterpillar. We don't know what kind of transformation is going to happen. We can go in explicitly looking for a transformative experience, which I think most volunteers for pro bono and clinic do, but we cannot guarantee what that transformation will be, or whether that transformation will be the happy narrative that perhaps people are hoping for. I think quite often transformation is messy, it's difficult, it's painful. There are lots of challenges, both to the worldview and to the self. And some people, do not feel themselves to be particularly transformed by this experience. And we really need to make space for that and to make that okay. That unless you had a come to Jesus moment during clinic, it wasn't worthwhile. Well, we can't be doing with that, can we? So I think there's something that we talked about in the pre-meeting that I really wanted to bring up. This is Nathan's idea, that the clinic is essentially a liminal space, in which our role as the people who kind of create and hold that space is to be very clear about all the things that might happen in that space and provide a lot of space, feedback, reflection, almost supervision in a more clinical sense than perhaps the traditional supervision of practice, so that people actually can deal with those transformative experiences or not having the transformative experience that they hoped for, so that we don't reify clinic, so that it doesn't become this thing that you have to do it right. Because I think what we've always said is it's most important that people are doing it. And then, there will be benefits, but they may not be immediate and they may not be the things that you thought they would be.
Just to say, transformation is often a painful process. And I think one of the things to flag up as well when we're talking about the ethics of doing this work is that having a painful or difficult experience while doing pro bono doesn't make it doesn't by definition make it an unethical experience. And part of the thing of being someone who is supporting or facilitating these clinics is to help people understand that. So that could be all sorts of things. It could be having a very, let's talk about it really practically here. It could be having a very upset client who shouts and cries and accuses you of doing something that you haven't done as a volunteer. It could be losing a case. It could be all of these things. I've had to do some really quite intensive coaching and reparatory work when someone lost 2 cases in a row, and it was really, really hard for him. And I'll keep that one with me. And that was really tough. There wasn't anything unethical that had gone on there, either in his work, the work that he had done, the standard of work that he had done, or in us putting him in that position. He was very well able to deal with it. But then it would have been unethical if we hadn't then done the work afterwards, the supportive work afterwards. And I think that's where we're really talking about the ethics of pro bono. Let's talk about it holistically.
Doesn't that, in fact, impose a real duty on those people who are managing and supervising what goes on in, say, the law clinics or a pro bono setting? And doesn't it also raise concerns about those environments which may not be properly supported or staffed by their universities, so that the people actually doing the pro bono work and advice don't have the support if they are challenged, or if something goes wrong, or they've just seen somebody who says, look, I'm a victim of abuse, what do I do? And they don't have somebody who can help them with that.
Yes, absolutely.
Absolutely, yeah. And that was actually the point that I was going to follow up with, and that I do believe that we as pro bono managers have a duty of care, not only to the ultimate client, but also to those lawyers who are participating in these pro bono programs. So I have had or I've heard of examples where people have participated in benefits appeals, and the individual in question has been suffering so much from other social problems that they have committed suicide during the course of the case, which obviously is very traumatic for the lawyer involved, who is doing this in their spare time, their lunch times, and thinking that they are actually doing some good. To be faced with that is quite difficult to deal with, not only for the individual but also for the practice. Similarly, I myself have had experiences where I've been off doing field work in Colombia and interviewing human rights victims as part of a pro bono program, and being faced with first-hand stories of women who have suffered from sexual violence over prolonged periods of time. And as a young lawyer, I found that particularly difficult to deal with. And so in my role, I'm very much aware that we need to put in place protections or programs to protect against the possibility of secondary trauma, particularly when dealing with issues such as human trafficking, for example, or domestic violence. But even those pro bono cases where actually you wouldn't necessarily expect there to be a knock-on traumatic event occurring, because the reality is that those are more likely to occur in the pro bono space. You're dealing with vulnerable individuals and not-for-profits who are operating in these quite tricky scenarios, as opposed to commercial cases where you're dealing with professional lawyers who are working for companies, for example.
Okay, thank you. Now, I think we've got a little over 5 minutes to go. I don't know if anybody else outside of the panel has any questions for us. If so, do you want to put them in the chat room?
While people are typing, can I just loop back to Stephen? Because I think that this is something that should be part of our minimum standards as a profession. I think that the reason that we have such poor mental and physical health in the legal profession, that we have such high levels of dropout and burnout, are because this is a systemic issue. We're very conscious of what we need to be doing to hold each other in clinic, or certainly the people who've been speaking today are very clear about this. I don't think we're very good at that across the profession, whether that's in large firms, small firms, lawyers within other businesses, lawyers working for government and other sort of fourth sector bodies. I think actually this is one of those moments where we could get an enormous amount of benefit from the regulators demanding that this kind of supervision, support, awareness of what happens for all lawyers was something that we all had to take account of. So that's my last little bit.
I totally agree.
Nathan.
Oh, just to say, I totally agree. that's really all I needed to say on that one, I think.
Do you think it's realistic?
I think we've put into place as a profession an awful lot of other regulation that has been accepted and has happened, and I don't think the mental health and well-being of lawyers and caseworkers is any less important. So yes.
Okay.
In a word. Sorry, that's a very quick answer to that one.
No, not at all. In the last 5 minutes, I sort of just got a couple of questions that I wanted to ask James to consider. Firstly, to what extent do you think lawyers and law students doing pro bono work impacts on public perception of lawyers? And secondly, in the event that some pro bono became mandatory, and I certainly think Michael Gove a couple of years ago was talking about it, what impact, if any, do you think that might have again on either the ethos of pro bono or the public perception of pro bono work?
On public perception, I think it can if we're able to tell better the story about pro bono, the work that both solicitors, professionals, and law students do, that does and can and will have an impact on public perception of the profession. But I think we're not very good at telling that story sometimes. And we need to be shouting it from the rooftops, really, and being much better at communicating what it is that gets done pro bono. But it's a communications challenge, and it's a communications challenge because first thing you talk about when you say pro bono is you've talked a Latin word which nobody understands. So there's a big communications challenge. On the question of mandatory pro bono, and would that again change the perceptions or Well, I mean, as I said earlier, we are certainly uneasy, if not resistant, to ideas of mandatoriness in pro bono, because by definition, it needs to be, it is voluntary. I mean, but there are, I think, ways of very hard, both soft but also very hard kind of incentives that you can introduce. However, if you make it a kind of absolute regulatory requirement, there is a risk that the voluntary element sort of drops off and people, it's not seen as being voluntary, and therefore it's not seen in that same sort of altruistic framework anymore, but rather just something that lawyers have to do, tick a box. And so I think it's a nuanced debate, but it's I do urge caution when people talk about there are some easy, quick win solutions by making a pro bono mandatory and making that a kind of big contribution to access to justice in that way, as Michael Gove sort of alighted on.
Thank you. I think that sort of more or less brings us to the end of this session. So can I thank my four panelists, James, Nathan, Victoria, Elaine. I personally found the discussion really interesting, and it's the sort of thing that I think we could debate and discuss for hours on end without any difficulty at all. I know that the point that you were making about possible regulation or more oversight of sort of law clinics and pro bono generally is something that I'm sure Omar is going to pick up in the second session and fits quite nicely within that. So yeah, as I say, can I just thank all four of you for your contributions this morning. I hope you enjoyed it, and please feel free to stay for the second session if you want to. So thank you very much.